We're in this case, folks, for one reason, because this note got changed. That's the only reason we're in this case. Because the Buckalews would never, for 6 months, have allowed Peter Futrell to continue to take care of their son. If they thought he was so incompetent that he would ignore information about chiropractic, they would never, for 6 months he kept coming and seeing their son. If they had known that he bungled a call after being told about a CTA and a chiropractic, what they thought, but he had to be brought into the suit because the records were altered. This is the record they got when they got the medical records to see what happened. So when they got the records say Womack called Futrell about a CTA. That's what they said. That's the one note that was changed, where they talk about the Vaser-Arley filling. The second note, and that you've seen it all. I think it's one of these is plaintiff's 13 and one is plaintiff's 14. One shows the native note, one shows the changed note. This was all added the next day after he was tipped off by Mr. Nickham that there was a problem. And then this note is added. They added the CTA. So when they got the native note, and their good lawyers looked at the note and said, wait a minute, Womack called him about the CTA. We've got to include Futrell in the suit, because if not, they're just going to say, well, we called him and he didn't respond. That's why he's in the case, because of this note. If the native notes are there, there's no documentation he was told about CTA. Even when the note was changed, he never added the chiropractic business.